everyone. Thank you for joining us today for Constangy's webinar, Mid-Year Labor and Employment Law Update, Key Developments and Compliance Strategies. A couple of housekeeping items before we get started. If you have questions throughout the presentation, please submit them through the chat function. You can access the chat through the toolbar located at the bottom of your screen. Our presenter may not be able to address all of your questions during this session, but we encourage you to reach out following the presentation. Her contact information will be included in our post-webinar follow-up email. This program is approved for Sherman HRCI credits. We will be sharing those codes at the end of this presentation, so please stick around in order to get them. Lastly, we'll also be sending out a copy of the slide deck along with a recording of today's session. These materials will be sent to you once the recording has been uploaded by tomorrow morning. I'm now going to turn it over to today's presenter, Kim Seten.
Hi everybody, good afternoon, and thank you for joining our webinar today. It's a mid-year labor and employment law update. I will say, as I started putting this presentation together, I was a little surprised at how much has happened over the last few months that we have to talk about. And frankly, to quote the great philosopher Ferris Bueller, life moves pretty fast. So today we're going to cover quite a few different topics, including recent court decisions and some key takeaways from those. We're going to talk about a recent executive order and also some legislation that has impact for employers. We're going to talk about what's going on at the federal agencies and how that impacts your business. And then we're going to provide state law updates as well that talk about laws that have recently or are going to take effect in various states. So let's jump in and get started with some recent Supreme Court decisions. The first decision I want to talk about is Ames versus the Ohio Department of Youth Services. In this case, the plaintiff, Ms. Ames, she was a woman who I identified as straight, and she applied for a promotion and was denied that promotion, which was then given to a gay employee. She sued, alleging that she was discriminated against on the basis of her sexual orientation and her gender. And her case arose in the Sixth Circuit. And the district court granted summary judgment in favor of the employer, which the Sixth Circuit affirmed, saying because she was a straight woman, i.e. being straight, being a member of the majority, she had to show some additional background circumstances showing that her employer was the unusual employer who discriminates against the majority. And the courts of the 6th, 7th, 8th, 10th, and DC circuits, so a good swath of the country, had that requirement for reverse discrimination claims to say if you are going to bring a reverse discrimination claim, then in addition to your prima facie case, you're going to have to show some other evidence to show that your employer kind of deviates from the norm by discriminating against the majority. Supreme Court considered that and found that there is no heightened evidentiary burden under Title VII on majority group plaintiffs. So the evidentiary burden remains now the same for every individual who brings a claim under Title VII alleging discrimination. And there is no requirement that plaintiffs have to demonstrate this background circumstance that shows that their employer is the unusual employer that discriminates against the majority. Why do I mention this case? One, it's possible that employers, particularly in those circuits that I identified that had that heightened burden, we may see more reverse discrimination claims. There certainly may be more claims alleging that individuals who are white or who are straight or who are Christian are being discriminated against, even though they are part of what may be considered the majority in their area. It's also possible that just because of the Supreme Court decision, other areas may see more reverse discrimination claims as well as, there's publicity about this issue. I think that this is always a good reminder that employers should take every complaint seriously, even if it is a reverse discrimination claim complaint. So regardless of what type of complaint it is, even if it's a white employee saying they were discriminated against on the basis of their race, you should investigate that just like you would any other complaint. Make sure you're investigating thoroughly, taking any appropriate prompt remedial action. Make sure we're documenting all of our investigations. You want to make sure that your policies and procedures are being applied consistently and neutrally across your organizations. So again, there's no ability for someone to make a claim that there are policies or procedures that are more preferential to minority employees than to majority employees. And again, as I tell every employer, we want to make sure that any adverse employment actions that we're taking against our employees, that we have documentation on the reasons for those, and that we can demonstrate legitimate, non-discriminatory reasons for the actions that we're taking. So moving on, another case that the Supreme Court decided this term was Stanley versus the City of Sanford. And this case involved a retired firefighter who sued the city of Sanford, Florida, and said that the city reduced her health insurance benefits as a retiree because of her disability. And she said that that reduction in benefits violated the ADA. The Supreme Court held that the ADA does not protect retirees who are no longer employed and who no longer want to seek employment. So in other words, the employment provisions of the ADA only apply to qualified individuals who currently hold or who want to hold a position with an employer and can perform the essential functions of a job with or without reasonable accommodation. So if someone has removed themselves from the job market because they've retired, they are no longer covered by the ADA. So I think that's helpful. Again, precedent to understand when someone is potentially considered a qualified individual with a disability for purposes of whether they have to be accommodated and for purposes of whether you can take certain actions against them and have that not run afoul of the ADA. Another case that I wanted to mention, and this is not an employment case, was the Trump versus Casa Inc. Case that the Supreme Court recently decided. And in that case, there was, a nationwide injunction that was issued by a district court. And the Trump administration went to the Supreme Court and said that a district court, i.e. the lowest level of federal courts, should not be able to issue a nationwide injunction because that exceeds the authority of the district court. And the Supreme Court held that universal injunctions do likely exceed the equitable authority of the district courts. So again, while I say this isn't an employment case, the reason that I want to mention this for employers is there are potential implications down the road. For example, during the Obama administration, when the administration published regulations to change the salary amount for the white-collar exemptions, there was a nationwide injunction issued by a court in Texas that put a hold on those being put into place for the entire country. Now, with this Supreme Court precedent, arguably, there will be inconsistent, potentially, enforcement of agency, putting pause on agency actions depending on where cases are filed, what courts are making those decisions. So we will see fewer nationwide injunctions, which for employers could lead to, having different obligations in different jurisdictions depending on where different agency actions are challenged. It's even possible that you could see different enforcement in the same state, because certainly there are states that have, multiple district courts. And if a district court in one district issues an injunction, that would not necessarily mean that would apply across the state as well. So that's just something for everybody to keep their eye on, that this is going to be a developing area as potentially the Supreme Court, considers more issues related to nationwide injunctions. Now, this decision did not have any impact on class actions under Rule 23. So there's nothing stopping plaintiffs from bringing class actions under Rule 23 on a nationwide basis. And it also did not address challenges to agency actions under the Administrative Procedures Act. So those, remedies are still available, and there could still be nationwide or what are considered universal injunctions or universal action in regard to those types of legal vehicles. But I think we will see fewer nationwide injunctions going forward when plaintiffs are challenging to stop federal agencies or, the administration from taking some type of action. All right, I want to talk about a couple courts of appeal decisions as well. The Keene versus Chili's Inc. decision. So in this case, the plaintiff, Mr. Keene, he was assigned a new supervisor. And over the next several months after he was assigned this supervisor, another employee made complaints about him. And those complaints were talked about via email amongst a group of decision makers. Ultimately, the decision was made to terminate his employment. The problem came, as you know, litigation can take several years by the time the decision is made until we're actually in litigation. And by the time the litigation was well underway and it was time for depositions for the company's decision makers to step up and say, I participated in the decision to terminate his employment and here's why we did it. None of the individuals who were responsible for the decision could remember what their role was in the decision or why the decision was made to terminate employment. Unfortunately, because the company also had not instituted a litigation hold soon enough, all of the underlying emails that discussed the complaints and the reasons for the termination were no longer in existence. So all we had left was one report that was prepared by one of the decision makers. However, during that person's deposition, they didn't remember drafting the report and they couldn't say, yes, in fact, that is a document I authored. So then ultimately, the Court of Appeals said you couldn't rely on this document to show the reasons for the termination. And in fact, because everybody said they couldn't remember their role in the decision, the only person that could be credited was the plaintiff and the plaintiff's testimony about the reasons for his termination. So certainly a problematic case for the employer in this. Oh, and some key takeaways from this case. Adverse actions don't just happen. Someone isn't terminated out of the ether. People make decisions at companies. And often claims of discrimination turn on someone's motivations. I mean, in essence, what a plaintiff is saying is the person that made the decision to terminate my employment or not give me a promotion or whatever action they took had a discriminatory motive. If the company has no decision maker who is able or willing to recall the decision and to testify as to the reasons of that, that can be really problematic. So it's very important that companies have decision makers. And I think this also shows that it is very important that documentation be maintained and that litigation holds be implemented as soon as you are aware of the possibility of litigation. Because in this case, the underlying documentation could really have helped Chili's, but it was no longer there. And the one document that was left, no one was there to authenticate it. So really important that when we're making these decisions, we know who's making the decision and we're documenting it and maintaining those records. Another case I want to talk about was Shear versus the Sisters of Charity of Leavenworth. And in this case, this plaintiff, she was being put on a performance improvement plan. And right before the performance improvement plan was implemented, she made some very concerning comments to her coworkers that made the employer concerned for her mental health. So they added to the PIP the requirement that she participate in the company's EAP. The employee was very upset about the referral to the EAP and said she would not participate in it. And ultimately, she was terminated because she refused to agree to the terms of the PIP. She sued and said, that she was discriminated against on the basis of her disability. The company regarded her as disabled by requiring her to participate in the EAP. Initially, the district court dismissed her case, saying that there was no adverse employment action because asking someone to go to an EAP is certainly not an adverse employment action. The case went up to the 10th Circuit, and in the interim, the Supreme Court last summer decided the Muldrow versus City of St. Louis decision, where they said that instead of requiring significant or serious harm for an adverse employment action, instead plaintiffs now just need to show some harm. So the 10th Circuit has sent this case back to the district court to say, district court, you now need to consider, is a referral to an EAP, a mandatory referral, is that an adverse employment action under the new standard in Muldrow? And I cite this case because, I mean, it's very possible that when the district court considers it, they will still find that that was not an adverse employment action and that that did not constitute some harm. But I point this case out because under Muldrow, employers have to be very careful in the decisions that they are making, because it's no longer, an adverse employment action has to be something like a termination or a denial of a significant promotion or a reduction in pay. This some harm principle can lead to a lot more types of adverse actions being considered to be truly enough to sustain a prima facie case and to get past summary judgment. So when you're making decisions regarding employees, again, we want to make sure that we're making all of our decisions for non-discriminatory, non-retaliatory reasons that we're able to substantiate. Next, I want to talk about an executive order and some legislation. And the executive order I want to discuss is the Restoring Equality of Opportunity and Meritocracy executive order that was issued back in April. And this was an executive order by the Trump administration that, in essence, articulates that it is the intent of the federal government to move away from enforcing claims of disparate impact. And as a reminder, a claim of disparate impact, it's a type of discrimination that says that a facially neutral policy or practice disproportionately harms a protected group, even if there was no intent to discriminate. So, for example, we've certainly seen a lot of litigation involving hiring software or AI hiring tools that plaintiffs argue might have bias implicit in them, where they exclude members of minority or exclude women from consideration. And even though the software on its face is supposed to be neutral, unfortunately, it leads to some type of disparate impact. So the executive order says that federal agencies are to shift their enforcement priorities away from disparate impact claims. The executive order also says that the EEOC is to issue technical assistance to employers and other federal agencies on the priorities and moving away from enforcing this. And the executive order also questions the impact of regulations that have been issued around Title VII and other laws, and say that federal agencies should not consider or should no longer use those regulations. With all of that said, I want to point out that this executive order does not revise Title VII. Title VII is a law, and portions of Title VII do discuss disparate impact. Instead, what we can understand is the federal government, so the EEOC, is likely not going to have an enforcement priority of looking at disparate impact claims, and in fact have been directed not to do so. However, because this is still in Title VII, and there's still also a very large body of case law involving disparate impact claims, including Supreme Court precedent, private litigants can still pursue claims of disparate impact. So this is not a great, we no longer have to look at our policies and procedures or the software that we're using. We don't have to consider any impact that it may have on our workforce. I want to point out, employers do still need to make sure that you're ensuring that your policies and procedures don't have, an unintended consequence of discriminating against members of any type of minority, but we're not going to see that enforcement at the federal level. Legislation I want to talk about, on July 4th of this year, President Trump signed the One Big Beautiful Bill into law. And there are certainly a lot of portions of that law that potentially impact employers, but the one portion I want to talk about and put on your radar, if it's not already on your radar, are the section that addresses taxes on tips and overtime. So the law contains a no tax on tips and a no tax on overtime provision, which take effect this year and are in effect until December 31st of 2028. So in regard to tips, employees who customarily and regularly receive tips Those employees can deduct up to $25,000 from their income, subject to federal income tax, starting with this tax year. And then for employees who earn overtime, those employees can deduct up to $12,500 in overtime pay from their income, again, starting this tax year. What do employers need to do? So first, you have to make sure that if you have tipped employees and if you have employees who earn overtime, that your systems can allow you to report for tips the total of cash and non-cash tips and the employee's occupation on their Form W-2 starting for this tax year. And if you have any tipped contractors, that you can report the same information on their Form 1099 for non-employees. The Treasury Department is supposed to publish a list of occupations that have customarily and regularly received tips. So unfortunately, you cannot put out a tip jar for your receptionist and let them start getting tips and make that deduction on their income taxes. Instead, what they're talking about are servers, waiters, waitresses, bartenders, barbers, hairstylists, those types of occupations that regularly receive tips. And hopefully we will actually get that list from the Treasury Department before the end of the year. In addition, if you have employees who earn overtime compensation, then you have to be able to report qualified overtime compensation on a W-2 for employees and on Form 1099, although there were not. So qualified overtime compensation. So let's remember that this applies to federal income tax, and it's overtime compensation as required by the Fair Labor Standards Act. And the Fair Labor Standards Act requires, time and a half after 40 hours of work in a week. So if, for example, you pay double time for your employees' overtime, you would only be reporting the time and a half portion, not all of the overtime. So it's really important that employers start thinking about this now and making sure their payroll and HR systems can take, all of that into account so that you can make sure that you are producing compliant W-2 and 1099s at the end of the year. If you're an employer, for example, that has salary exempt employees, but you choose to pay those employees a premium over and above their salary for hours worked, over 40 in a week, you can't, that would not be overtime that they could deduct from taxes, because that's not overtime that's required by the Fair Labor Standards Act, because they're salaried exempt employees. So it's just very important. I think this is going to be an administrative burden on employers, and it's really best to get started on it now instead of needing to try to scramble and do that at the very end of the year or in January of next year to make sure you can produce those. The IRS is supposed to produce regulations and publish those this year on guidance for employers and what employers need to be doing. But again, we can't trust that those will come in a timely manner. So let's make sure we're getting these systems in place. And of course, when you're making changes, it's always a good idea to talk to your tax counsel, to talk to your accountants or whomever is helping on that end with things as well, because hopefully they'll be up to date on the latest as it relates to that as well, as it relates to changes that are coming. Well, let's talk about what's going on at the various federal agencies. And we're going to start with the EEOC. Currently, after President Trump dismissed 2 sitting Democratic commissioners, the EEOC has been operating with only there's only 2 commissioners currently. The president has nominated Brittany Panuccio to be a member of the U.S. Equal Employment Opportunity Commission, and if she is approved as a commissioner, then there would be 3 commissioners, and it would be 2 Republicans and 1 Democratic commissioner, and they would finally be able to start publishing guidance and priorities and things like that as well, that they cannot really do while they're just sitting there with 2 commissioners. I mean, certainly we expect that once there is a quorum of commissioners, that they will start working on carrying out things that the Trump administration has said are priorities, including issuing guidance on DEI programs. We anticipate that it's very likely that they may narrow or even eliminate some of the guidance and regulations on the Pregnant Worker Fairness Act. Certainly, we anticipate that there will be perhaps a change to gender identity protections under their sexual harassment guidance, probably in updated information on national origin discrimination. So we anticipate that those will happen once she is actually confirmed, which that confirmation has not yet happened. EEO-1 reports for those employers who were required to submit those were due June 24th. That submission process is closed and they are not accepting late submissions. So I hope that everyone got their EEO-1 report submitted. And if you didn't, feel free to reach out after and we can talk about what you need to do in that regard. Within the last few months, the EEOC has published a new technical assistance document entitled What to Do If You Experience Discrimination Related to DEI at Work. And this document is talking about things that employees might be experiencing that the EEOC now says is DEI related discrimination. And they've provided some examples in this technical assistance guidance, such as implementing quotas or balancing a workforce by race, gender, or any other protected category, excluding individuals from training or mentorship opportunities or sponsorship programs on the basis of their protected characteristics, selecting only certain people for interviews based on protected characteristics, limiting membership in employer resource groups to certain protected categories, or separating people based on their protected characteristics when you're conducting training. Somebody just asked where you can find this. This is on the EEOC's website. You can go, I think it's on the landing page as a link, but you can definitely go to their news section and scroll down and it will have a link to when they released this to the public. As a corollary, along with that guidance, they issued some corresponding FAQs as well, entitled What You Should Know About DEI-Related Discrimination at Work, which give examples of DEI initiatives that may be unlawful under Title VII, including, obviously hiring, firing, promoting people because of a protected category, which is not related to DEI. That's actually what Title VII says is discriminatory, but also providing special access to training based on a protected category or not allowing certain categories of people to participate in training. Again, that access to mentor opportunities or workplace networking opportunities or employee resource groups. Having internships or fellowships that are only limited to a certain category of protected characteristic, or making sure you're limiting your pool of potential hires based on some protected characteristic. The guidance or the FAQs do say that certain DEI training in and of itself can constitute workplace harassment if it's discriminatory in its design, content, or exclusion. Now, they don't provide any concrete examples of what type of training might violate Title VII, but they do drop a footnote and say that unconscious bias training may be problematic. That's the best we've got. So again, this leaves employers kind of in a little bit of limbo as to the types of training to provide and what the agency going forward might decide would be discriminatory, but I do encourage everybody to take a look at those. Turning now to OSHA. OSHA has expanded its small employer penalty reduction program. This is a program by which small employers can get up to a 25% penalty reduction if they have an effective safety management system, even if they have a violation. And previously, this was limited to employers who had 10 employees or less, and now they've increased that to 25 employees or less. So that's, a good opportunity for smaller employers to get that penalty reduction. I will say that OSHA entered this current administration understaffed. And we anticipate that there will be further reductions based on certainly the budget that has been presented and some of the intended layoffs that we have seen. So I think employers in regard to OSHA will expect less enforcement. And they're currently involved in some major rulemaking, particularly as it relates to heat injury. And it's unclear as to whether with the lowered head count and the lowered budget, if we're going to actually see the OSHA regulations that they've been working on for quite some time come to pass. Talking about the NLRB, similar to the EEOC, the NLRB currently does not have a quorum. This is another federal agency that has 5 board members, 3 of whom are generally the same political party as the administration in power, and then 2 from the opposing political party. And right now they only have 2, 1 Republican and 1 Democrat. So without a quorum, the NLRB cannot issue decisions, and they really can't do a whole lot. The president has nominated 2 new potential board members who would both be Republican appointees, Scott Mayer, who's the chief labor counsel at Boeing, and James Murphy, who is a career attorney. He's been with the NLRB since the 70s. The president has also nominated Crystal Carey, who's an attorney at Morgan Lewis, to serve as the new general counsel. But again, all of this is dependent on the Senate confirming these individuals. So it could still be quite a while before we get confirmation of these individuals, which means the NLRB, is sort of at a standstill in terms of issuing decisions. What it's not at a standstill in regard to, however, is general counsel memorandum. And general counsel memorandum are what the field offices of the NLRB use to kind of determine their priorities in terms of litigation. And so William Cohen, who's been appointed by the president as acting general counsel back in February, he revoked 29 general counsel guidance memorandum from the previous general counsel, Jennifer Abruzzo, which for any of you who followed the NLRB during the Biden administration, Jennifer Abruzzo certainly issued a lot of guidance memorandum that took very aggressive positions that were not favorable to employers. Some of the guidance memorandum that were revoked include what remedies that the NLRB would seek when in unfair labor practices, revoked guidance memorandum limiting an employer's ability to electronically monitor employees, revoked memorandum addressing the limitations on severance agreements under the McLaren-McComb decision. The NLRB had published that they found non-compete agreements to be violative of the National Labor Relations Act, and that has been revoked. So there's been a lot of good change for employers in terms of revoking these general counsel guidance memorandum. And in fact, the acting general counsel back in May did issue a new guidance memorandum on settlements, which helps employers and shows that the NLRB is going to return to a much more reasonable and balanced approach to settling unfair labor practice charges, including non-admissions language in settlement agreements, not requiring 100% back pay, and allowing and approving individual settlements between employers and charging parties. So it is nice for on the employer perspective to see a return to a more balanced NLRB under the current administration. In regard to the Department of Labor, in May, the Department of Labor's Wage and Hour Division announced that it was working to reformulate the test on independent contractor status and how that is determined under the Fair Labor Standards Act. So as part of this announcement and guidance, the DOL said that it will no longer enforce the 2024 rule that was established under the Biden administration. Instead, the DOL said it has reverted back to 2008 guidance, which addresses the economic reality framework for deciding if an individual is an independent contractor rather than employee. And those include, the extent to which the services rendered are integral part of the employer's business. Is this a permanent relationship? Have they been an independent contractor for 4 years? Maybe weighs against finding them to be an independent contractor. The amount, of the alleged contractor's investment in facilities and equipment. Do they have to bring their own equipment? Do they have to provide their own tools to do the job? The nature and degree and control of the employer. So is the company dictating everything that's being done by this individual, such that perhaps that weighs against finding independent contractor status? Whether the independent contractor has opportunities for profit and loss. Can they go out on the open market and compete? And are they doing that? Are they serving as an independent contractor for other companies? And the degree of independent business organization and operation. So all of those taken together are what the DOL is going to look at going forward in regard to independent contractor classification. Now, a few takeaways from this. Even under this economic reality test, we still see companies improperly classifying employees as independent contractors. So this is not a sort of get out of jail, you can classify anybody as an independent contractor. You still need to make sure you're doing an analysis and ensuring that someone truly is an independent contractor. I also want to point out that there are state laws that may apply that have stricter classification requirements with regard to independent contractors. So not only do you have to look at the federal level, but you have to see, are there any state laws in the states we operate in where this may be problematic, even if it's not problematic at the federal level. While the DOL has said it's not going to enforce the 2024 rule, for purposes of private litigation, that rule is still in effect. So plaintiffs can still bring claims for misclassification under the 2024 rule. And lastly, I want to point out that this is one of those rules that we see go back and forth depending on the administration in power. So always kind of be mindful of the fact that what may be okay under one administration, if there's a change in administration, becomes more fraught with risk and needs to be reevaluated. Now I'd like to turn to changes in state laws that have recently or are going to take effect. Alaska's minimum wage increased to $13 an hour starting July 1st. In addition, under their state paid sick leave law, accrual began July 1st as well. So for covered employers under the law, employees will accrue 1 hour of paid sick leave for every 30 hours worked. In addition, Alaska passed a law that says that employers cannot hold captive audience meetings for the purpose of sharing political or religious views. So we're seeing more and more states pass captive audience meetings, which are often used by employers in the context of a union organizing campaign to have mandatory employee meetings where the employer delivers their message and their explanations for why having a union in the workplace is not a good idea for the employees or the employer. And we're seeing more states pass laws limiting an employer's ability to do this, Alaska being the most recent. In Colorado, the Colorado Privacy Act, the legislature passed expansion to that act, which took effect July 1 of this year. So for employers, what they need to know is if you are using biometric data of your employees, you have to obtain written or electronic consent. And what is biometric data? That's fingerprints, voice prints, retina or iris scans, facial recognition. If you're using that for identification purposes, you have to make sure you're obtaining written consent from the employees before you collect that data. In addition, if you change what you're collecting or what you're using it for, you have to get a new consent. So let's say everybody has to clock in and out with a thumbprint, and you decide to add voice prints as some type of identifier for employees, you would have to get a new consent to say, hey, we're collecting this information now as well. So for, Colorado employees who are using any type of biometric data collection, it's really important that you audit your practices, you make sure you're updating your privacy notices, and also getting any consents that you might need as well. Turning to the District of Columbia, effective July 1, the minimum wage for workers other than tipped workers increased to $17.95 an hour. And we were expecting to see a minimum wage increase for tipped workers at the same time. However, that doesn't take effect until October 1, and that minimum wage increase goes up to $12 an hour. Florida. Florida recently passed the Choice Act, and I apologize, it's an acronym, it's very long. I don't remember exactly what it stands for, but basically what Florida has done is become pretty much the most non-compete friendly state in the country. So Florida's Choice Act says that a non-compete agreement will be fully enforceable if certain requirements are met. The employee has to have 7 days to sign it, and they have to be advised in writing to seek counsel before signing. The employee needs to acknowledge in writing, obviously in the document that they're signing, that they're getting confidential information or information about customer relationships during their employment. During the non-compete, the employee has to agree that they won't assume a role for another business similar to the services they provided to their current employer during the 3 years preceding the non-compete period. So whatever the employee has been doing for you for the last 3 years, they can be prohibited from competing going forward should they leave their employment. And the non-compete period cannot exceed 4 years. In addition, the law says that provided certain conditions are met, including if the employee makes twice the average wage of an employee in the county, that a court has to issue an injunction. So if an employer goes to court to enforce a non-compete and all of these conditions are met, the court has to issue an injunction unless the employee who's departing or the poaching employer can demonstrate that there is no unfair competition. So again, this is, certainly helpful for employers who are seeking to institute non-competes. Also, the law says that employers can introduce non-competes at the beginning of the employment relationship or even mid-employment relationship, as long as the employee has that 7-day period to sign the agreement. So good news for employers in Florida who want to use non-competes. In Indiana, there was a new state leave law that was passed that took effect July 1. It's very limited in that it provides leave for employees to attend an attendance conference at their child's school or a case conference committee meeting, which is defined by statute in essence to really be an IEP meeting at their child's school. The law provides that the employee can attend one meeting per year. It is not paid time off. The employer can request documentation not only from the employee, but from the school to confirm that the meeting actually took place, and employers can ask that employees make a reasonable effort to have a video meeting instead of an in-person meeting to presumably limit the amount of time the employee is away from work. In Kansas, Kansas passed a law amending the Kansas Restraint of Trade Act. So similar to Florida a little bit, but not as beneficial to employers, but it does create conclusive presumptions for the enforceability of non-solicitation in agreements. And basically it's saying that if an employer is seeking to protect confidential or trade secret business information and their limitation is no more than 2 years, these are going to be considered to be presumptively enforceable. Again, it directs courts to go ahead and implement injunctions in those regards. It also mandates that if a court finds a non-compete provision to be overbroad, that the court has to reform it, or what we call blue pencil, i.e. make it so that it's lawful. Now, Kansas courts have always blue penciled non-compete agreements, but this actually codifies into law directing them that they are supposed to do that. Oh, sorry, I did not scroll. Okay, Maine. Effective September 24th of this year, there are changes in how earned paid leave time is accrued and carried over. So previously, the maximum accrual cap was 40 hours, and that has increased to 80 hours. And now employees, so they can carry over, and have up to 80 hours, and they will still accrue 40 hours annually. So previously, if, say, for example, an employee carried over 8 hours into the following year, then they could only accrue 32 hours that year. Now they can have an accrual cap of up to 80 hours, and they will always accrue 40 hours annually. There is no reduction in that accrual. With all of that said, the annual accrual and usage limits remain that the employer can limit that to 40 hours. So nothing has changed in regard to saying, here's how much leave time you can use during the year. Instead, they're just changing the accrual and the accrual caps. Missouri, as I sit here in Kansas City, Missouri has repealed the earned paid sick leave law that was passed by the voters back in November of last year, and which took effect on May 1st of this year. And it is now repealed as of August 28th, 2025. Unfortunately, the emergency repeal provision did not pass through the legislature, so the law is in effect from May 1st to August 28th. So I point this out to employers because it is important that during that time period, employees do still accrue leave, and employees cannot be retaliated against or terminated or, otherwise treated unfairly or differently because they use that leave. So this has certainly created a little bit of confusion and limbo for employers in Missouri, but you do want to make sure that through August 28th, you are continuing accruals and allowing people to use the leave under that law. I also want to point out that there is a potential impact on morale, which we're encouraging employers in Missouri to consider when you're taking away the accrual, if you decide that that's what you're going to do after August 28th, and plan for your communications on how you're going to explain that to employees. And unhelpfully, the Missouri Department of Labor still has not published any guidance on compliance during this interim period or what to do after the repeal. It's possible they will, but they may not as well. In New Jersey, effective June 1, the pay transparency law took effect that applied to employers who had at least 10 employees over 20 weeks and who do business and employ people in New Jersey. Employers have to disclose pay ranges and a description of benefits and compensation in job postings, including those for internal transfers. Employers have to make a reasonable effort to make current employees aware of promotional opportunities. And we're still waiting on regulations by the New Jersey Department of Labor and Workforce Development. So hopefully we will see some of those to provide some more guidance for employers. Tennessee, I want to point out that the Tennessee legislature has dissolved the Tennessee Human Rights Commission, which was the agency in charge of having enforcement power over the state's anti-discrimination laws, and that was dissolved effective July 1. Now, going forward, that enforcement power rests with the Attorney General's office, and individuals and employees who want to file charges will now file it with the Attorney General's office. Interestingly, what about those people that had pending charges before June 30th? Those will now be investigated by the EEOC. There's no need for those individuals to refile charges, but there's no longer a state commission or agency that is going to be investigating them. In Vermont, there's a pay transparency law that took effect June 1, and that applies to employers who have at least 5 employees with one based in Vermont. Employers have to disclose salary and compensation details in job postings for both new hires and internal promotions, which is very similar to what we see in all of these pay transparency laws that are being passed around the country. Also, covered employers, current employees have to be provided the salary range of their position upon request. So if an employee comes and wants to know what the current salary range is for their position, that would be information that would need to be provided as well. Also, Vermont introduced changes to the Parental Leave Act that are currently in effect. This expands the definition of a family member to include more non-traditional families, so domestic partners and civil unions. So, and then the children of those unions, your civil partners, your domestic partners, parents, all of that. It's definitely expanded who is covered as a family member. In addition, they now say that parental leave covers recovery from childbirth or miscarriage or to care for a foster child. So those have been added to what the definition of parental leave includes. And also, in addition to parental leave, now employees are entitled to safe leave, bereavement leave, and qualifying exigency leave. Exigency leave is leave related to active duty service by a family member in the military, similar to the exigency leave allowed under the Family Medical Leave Act. Bereavement leave, employees are entitled to no more than 2 weeks of bereavement leave under this law, with no more than 5 work days taken consecutively. And then safe leave means leave because the employee or a family member is the victim of domestic violence, sexual assault, or stalking, and that leave can be used for things like getting medical care, counseling, social or legal services, recovery from injuries, or safety planning or relocating. So definitely make sure that your policies are updated in Vermont as to, the additional types of leave that is covered by the Parental Leave Act, and that you're making employees aware of that as well. In Virginia, so interestingly, we've certainly seen some states, Florida and Kansas, pass laws that are pro-employer in terms of non-compete legislation. And then we have other states that are passing legislation to make it more difficult for employers to have non-compete. So effective July 1 in Virginia, employers cannot enter into or renew non-compete agreements with employees who earn overtime under the FLSA. So previously, Virginia limited non-competes based on the amount of wages that are earned by an employee. Now they're saying if an employee earns overtime, you cannot enter into or renew a non-compete agreement with those employees in the state of Virginia. So definitely important to take a look at your existing non-competes to make sure, whether those need to be rescinded if you have those with employees earning overtime. Washington State has expanded its Equal Pay and Opportunities Act, which was effective July 1 of this year. And now, in addition to gender, the law provides for equal pay for a number of new protected categories, including age, marital status, sexual orientation, and you can see all of the different statuses, including disability status or the use of a trained dog guide or service animal by a person with a disability. So definitely a very significant expansion of the equal pay law, and you'll want to make sure, again, that you're updating your policies as necessary in Washington. In Wyoming, our last state, again, another state that is passing legislation prohibiting non-competes, and this was effective July 1. And the Wyoming law says that non-competes are void in the state except under certain circumstances. So for example, as part of the purchase or sale of a business, if the purchasing employer wants to limit the ability of the seller to immediately start competing, that would be okay. Where a non-compete clause provides for the protection of trade secrets, so there's truly trade secrets to be protected, where there's contractual provisions that provide for the employee that if you've provided relocation and education expenses and training, a non-compete can be appropriate in certain circumstances. And for executive and management personnel and officers and employees who are professional staff to executive and management personnel. Unhelpfully, the Wyoming legislature did not define who are executive and management personnel or officers and employees who are professional staff to those people. A lot of terms in the new law are undefined, which will make it a little more difficult for employers as this law is now in effect and we start to see, potentially litigation arising from it. I will say that Wyoming's law is very similar to one that was passed by Colorado. Colorado has since amended their law in some regards, but this definitely kind of mirrors that first law. So it is possible that early Colorado decisions may be helpful in interpreting the Wyoming law. I mean, we can't guarantee that a Wyoming court would follow Colorado law, but it might give us some answers. But I do want to put that out there that again, in Wyoming, there are only certain times that you can have a covenant not to compete. Again, that kind of leaves open non-solicitation agreements, whether those are still okay when you're not limiting someone's ability to compete, you're just limiting their ability to solicit customers. But that's definitely something to keep an eye out if you have operations in Wyoming and you're using non-compete agreements. So that is everything I wanted to cover today. I wanted to put up the SHRM and HRCI activity codes, and then I'm going to look at the chat and see if we have time to answer a couple questions before we conclude. And if I can't answer your question, I will reach out and answer your question as a follow-up after the course. Okay, let me see. The DEI document on the EEOCA said that was on the website. Someone asked if an employee in Florida has signed a prior non-compete, is that non-compete still effective, or do they have to sign an updated one with the updated language? So existing non-competes can potentially still be effective. You just have to make a strategic decision. Do you want to take advantage of the new law that says this is definitively what you have to do to make sure that your agreement is effective and that you can definitively get that injunction if you need to go into court to enforce your agreement? You can still have agreements under the prior law. It's just you're not going to be able to take advantage necessarily unless it has all the terms in it to allow you to get that immediate injunction if you need it. Someone asked what would be similar work for another employer, and that again, that would be a very case specific decision. But if you were if you were a salesperson for that employer, that would prohibit you from going and doing substantially similar sales work. If you were an HR person, that would prevent you from going and providing HR services to another employer. It wouldn't prevent you from going and being like a chief information officer, because perhaps that would be very different than what you were doing. So it's just gonna, it's going to depend on how similar the work that is being done can be analogized. Someone asked how pay transparency laws are enforced, or if state agencies are just out there monitoring them. And I will say, for the most part, state transparency laws are there. Some of them have private rights of action, some of them don't. But it is typically an unhappy applicant or an employee who did not get the information that they believe they should have gotten that are bringing those to whatever state agency is responsible for enforcing the pay transparency laws. I personally have not seen a lot of litigation involving pay transparency laws. I think we'll start to see more as they become more prevalent, but again, I think it's really more of an unhappy applicant or an unhappy employee who believes that perhaps the pay range they were given at the time of application is not actually accurate. All right, those were everybody's questions. I want to thank everyone for coming today. Again, Victoria said that she will send out the PowerPoint, and it has my contact information on it. If you have any follow-up questions, please feel free to email me, and I would be happy to answer any questions that you may have. So thank you, everyone. I really appreciate your time this afternoon.